The state house still has to vote on the bill. 9 on your side's Craig Smith looked into how much difference a suppressor makes.
Our neighbors to the east and west allow silencers.
The Supreme Court has refused to change laws that limit access to gun silencers.
Gun enthusiasts hope lawmakers will pull the trigger and lift the ban on silencers.
Why do we have guns? Why do we have the Second Amendment?
The legal showdown for firearm freedoms. Enter the legal fray that has captivated the firearms community, the Suppressor Freedom Lawsuit, a groundbreaking legal challenge against suppressor bans in select states. This legal saga is not just a skirmish, it's a seismic shift in the battle to uphold the right to own suppressors, those ingenious devices designed to mitigate firearm noise. At the heart of the commotion are two heavyweight lawsuits, the Morris v. Raul and the Anderson v. Rule cases, both flexing their legal muscles in the Federal District Court of Illinois. The resonance of these cases extends beyond the desire to own suppressors. They are a direct challenge to bans that curtail lawful ownership. Several states, including Illinois, impose bans on suppressor despite their legality and widespread use in 42 other states. These lawsuits transcend the ordinary legal discourse, boldly asserting that these bans infringe upon the Second Amendment, the cherished right to bear arms. The argument contends that these bans overstep constitutional boundaries, raising questions about their compatibility with the fundamental rights enshrined in the Second Amendment. This legal showdown is of paramount importance, as it pioneers a challenge against suppressor bans that appear incongruent with constitutional principles. These cases are not just legal battles, they represent a paradigm shift, questioning the constitutional validity of suppressing the right to bear arms.
The state house still has to vote on the bill. 9 on your side's Craig Smith looked into how much difference a suppressor makes.
Why do we have guns? Why do we have the Second Amendment?
Support for these lawsuits is swelling as they stand as vanguards against the prevailing norms. Advocates are rallying behind the cause, asserting that if 42 states find suppressors acceptable, why not here in Illinois? The essence of this legal battleground lies in the quest for freedom, the freedom to own and utilize suppressors without undue restrictions. It's a legal frontier, reminiscent of the Wild West, where these lawsuits aim to carve a trail towards securing Second Amendment rights unencumbered by unnecessary bans. Unraveling the Illinois suppressor standoff. Preparing for a deep dive into the legal battleground unfolding in Illinois, where the Morris v. Raul and Anderson v. Rule lawsuits are making waves in a federal district court. These legal skirmishes aren't your run-of-the-mill scuffles. They're poised to challenge suppressor bans in the land of Lincoln, injecting a unique intensity into the proceedings. Envision this scenario. Across 42 states in the nation, owning a suppressor is perfectly acceptable. However, in specific regions, including Illinois, bans on these noise-dampening devices are creating obstacles. These lawsuits aren't merely about asserting the right to own suppressors. They're robust challenges against bans that hinder lawful ownership. Morris v. Raul and Anderson v. Rule are capturing attention because they confront these bans head-on, entering the legal arena with metaphorical arms blazing. Their argument is clear. These bans infringe upon Second Amendment rights, the age-old guarantee of the right to bear arms. The significance of these lawsuits extend beyond the realm of suppressors. They aspire to set a precedent. A successful outcome could inspire similar challenges in other states grappling with suppressor bans. Essentially, they're advocating for equal rights, proclaiming, just because we're in Illinois doesn't mean our rights should differ from those in other states. These lawsuits are more than a snapshot of the present. They're architects of the future. By challenging these bans, they seek to ensure that fundamental rights are safeguarded for generations to come. Delving into the intricacies of these cases reveals their compelling narrative.
Our neighbors to the east and west allow silencers.
We have a Second Amendment because we understand in this country that there are some things, inalienable rights.
Do arm braces make firearms more powerful?
They do not. They do not.
The core contention is that these bans deviate from the essence of the Second Amendment. The lawsuits contend suppressors are common tools, not perilous contraptions. So why subject them to a ban? The aspiration is that these legal battles will serve as catalysts for change. Beyond the courtroom drama, they represent quests for fairness and rights, eliminating bans that appear antiquated in a landscape where the majority of states embrace suppressor ownership without reservation. In essence, Morris v. Raoul and Anderson v. Rule are at the forefront of challenging suppressor bans in Illinois. They embody hope for those championing the fundamental right to own and use suppressors without undue restrictions. Their success could potentially trigger a ripple effect, inspiring similar legal challenges in states where comparable bans exist. Second Amendment under fire. Illinois is shaking up the status quo, asserting that suppressors shouldn't be afforded the same Second Amendment privileges as firearms. They're taking a firm stance, contending that these noise-diminishing devices don't meet the criteria of being classified as arms. According to their perspective, suppressors are more akin to accessories rather than genuine arms. Their entire argument revolves around the notion that, since suppressors don't discharge bullets independently, they fall outside the protective scope of the Second Amendment. They're drawing a distinction between what qualifies as a bona fide arm and what is perceived as a mere enhancement for firearms. Essentially, it's akin to saying, sure, your firearm is covered, but that silencer, not so much. The crux of their strategy involves asserting that suppressors weren't envisioned by the Founding Fathers when drafting the Second Amendment.
Joseph Story, in his commentaries on the Constitution in 1833, quote, "The right of the citizens to keep and bear arms."
A silencer was used in the recent Virginia Beach massacre that left 12 people dead.
Reasonable to conclude that gun confiscations facilitated by laws requiring the registration and licensing of firearms.
They're making the case that the amendment specifically pertains to firearms and that suppressors are merely supplementary, like a stylish add-on for your favorite firearm. It's as if they're attempting to marginalize suppressors, suggesting they don't merit the same constitutional protection as arms. According to Illinois, the Second Amendment is exclusively about firearms and not inclusive of these noise-dampening attachments. However, this argument encounters complications when considering existing federal laws that categorize suppressors as firearms. Despite this federal classification, Illinois is challenging it, asserting that suppressors should be dismissed as trivial attachments rather than legitimate arms. Expanding the viewpoint, the broader interpretation of the Second Amendment encompasses various items related to weaponry or self-defense, not solely firearms. Illinois seeks to narrow this definition, advocating for a more exclusive focus on arms. The lawsuits filed against these restrictive views are pushing back. They contend that the Second Amendment isn't confined to antiquated notions or limited to the weaponry of bygone eras. Instead, they argue for an expansive understanding that embraces modern tools like suppressors under the protective umbrella of the Second Amendment. In essence, while Illinois attempts to exclude suppressors from constitutional protection, these legal battles are fervently advocating for an inclusive interpretation, asserting that contemporary tools deserve recognition within the expansive scope of the Second Amendment. The clash of interpretations is intensifying the legal battleground. Illinois unleashes legal tactics. In the legal arena surrounding suppressors, Illinois is making a bold move straight from the legal playbook, a preemptive strike with a motion for judgment on the pleadings. It's akin to attempting to declare victory before the first whistle blows, an ace in the hole to signal, case closed, nothing to see here, before the court proceedings even commence. Their primary goal? To dismiss the entire matter before it advances to trial, grounded in the argument that suppressors do not qualify as arms protected under the Second Amendment. They're essentially asserting, "Dear Judge, while we respect arm rights, suppressors are merely embellishments, not the core issue." How are they presenting this case? Employing a staunch position, Illinois aims to persuade the judge that suppressors don't meet the criteria to be considered arms within the revered Second Amendment. According to their viewpoint, constitutional protection is reserved for the main attraction, the star of the show. In their playbook, suppressors are relegated to the role of sidekicks, extras undeserving of the same level of protection.
The Supreme Court has refused to change laws that limit access to gun silencers.
Tyrants disarm the people they intend to oppress. Those are the facts.
After that shooting, President Trump suggested he would look into restrictions on gun sales.
Their argument pivots on the notion that when the Founding Fathers drafted the Second Amendment, suppressors were not part of the envisioned scenario. It's their contention that the focus is solely on arms, actual firearms, nothing more, nothing less. Essentially, they're telling the judge, to join the Second Amendment club, you've got to shoot bullets. However, the opposition in this legal showdown is not yielding ground easily. They're asserting their perspective, contending that the Second Amendment transcends the musket and rifles of bygone eras. It encompasses a broader spectrum, including modern tools like suppressors. While Illinois endeavors to swiftly conclude this case, the opposing side is steadfast, refusing to let this debate culminate in a rapid dismissal. They argue that suppressors unequivocally fall within the purview of what the Second Amendment safeguards. Their stance is clear. As times evolve, so do the tools, and the right to bear arms encompasses advancements such as noise-muffling devices. It's a classic clash of legal interpretations, a duel between narrow and broad views of the Second Amendment. Illinois seeks to cut the debate short, while the opposition gears up for a protracted legal battle determined to prevent a swift dismissal. In the end, the judge will wield the gavel, deciding whether this legal drama concludes or progresses to a full-scale production. The legal crossroads. Enter the age-old debate surrounding suppressors. Are they unequivocally classified as arms protected by the Second Amendment, or are they merely sophisticated accessories to firearms? This fundamental question lies at the core of the legal skirmish, where opposing factions argue whether suppressors should be granted the same constitutional protection as firearms. In one corner, Illinois and its proponents contend that suppressors fall short of meeting the criteria to be deemed arms under the Second Amendment. They depict these noise-mitigating devices as embellishments, akin to the garnish on a sundae, rather than the sundae itself. According to this perspective, the amendment exclusively safeguards actual firearms, relegating suppressors or the status of ornamental additions. The plot thickens when federal laws enter the fray with a contradictory narrative. Contrary to Illinois' stance, these laws categorize suppressors as firearms in their own right. Essentially, Uncle Sam's legal stance is a resounding endorsement, acknowledging suppressors as legitimate members in the firearms category. This legal tug-of-war unfolds as Illinois seeks to uphold the notion that suppressors are mere accessories, lacking the same protective status as firearms. Meanwhile, federal laws assert the equal standing of suppressors within the broader realm of firearms. What adds an extra layer of intrigue to this dispute is its implications beyond legal definitions. It delves into the tangible impact of individuals' rights. If suppressors are acknowledged as firearms under federal laws, it implies that they should enjoy equivalent constitutional protections. Conversely, if Illinois' argument prevails, it could result in restricting the rights of individuals desiring to own and utilize suppressors without undue limitations. In essence, while one side endeavors to downplay suppressors as accessories, the other side brandishes the federal rulebook, asserting their legitimate place within the firearm spectrum. It's a classic clash of interpretations, a legal puzzle with real-world ramifications, all orbiting around fundamental question of whether suppressors are mere additions or genuine firearms in their own right. California legal ripple effect. Recent court decisions in California, notably in Miller v. Bonta and Duncan v. Bonta, have set the legal stage ablaze by deeming certain firearm restrictions unconstitutional. This significant shift in California's legal landscape is not just a local affair. It's reverberating across state boundaries, notably influencing the ongoing suppressor case in Illinois. In the courtrooms of California, judges made a bold statement, deeming specific firearm restrictions unconstitutional and effectively altering the trajectory of the legal battle for firearm rights. The intriguing twist lies in how these Californian legal pronouncements are resonating thousands of miles away in Illinois, particularly impacting the fight against suppressor bans. In the Illinois suppressor case, legal strategists are pointing to the California rulings as precedent, asserting that they carry weight and relevance for their own legal battle. They wield these rulings like a powerful tool, contending that if California restrictions were declared unconstitutional, perhaps similar bans on suppressors in Illinois should face a comparable fate.
since it offers a strong moral check against the usurpation and arbitrary power of rulers.
The ruling leaves in place a federal law requiring the registration of silencers.
In Cambodia, the Khmer Rouge were able to take advantage of the fact that limited gun ownership.
They function as a blueprint, suggesting that if California firearm restrictions were found unconstitutional, the bans on suppressors in Illinois should undergo similar scrutiny. The advocates behind the Illinois suppressor case are unabashedly leveraging these California decisions, citing them as persuasive evidence and a source of hope in their fight against suppressor bans. It's akin to saying, look, if firearm restrictions in California were deemed unconstitutional, then perhaps these suppressor bans in Illinois should face similar scrutiny. This isn't just a localized legal skirmish. It's a narrative unfolding across state borders. The California cases have transitioned from regional headlines to integral chapters in the broader story of constitutional rights and firearms regulation. As the drama unfolds in Illinois over suppressor bans, the California rulings play a supporting role, standing as a precedent that could potentially tip the scales in favor of those advocating for the right to own and use suppressors without undue restrictions. These rulings have transformed into more than legal victories. They've become symbols of hope and influence in a broader fight for rights across various states. The ripple effect. Triumphs in firearm-related cases extend their influence well beyond the confines of individual jurisdictions, creating a ripple effect that resonates throughout the entire legal framework. These victories aren't isolated achievements, but rather dominoes that possess the potential to sculpt the outcomes of broader battles for firearm rights across the nation. When a jurisdiction secures success in a Second Amendment to a case, perhaps by successfully challenging specific firearm restrictions, it's not merely a localized celebration. Instead, it becomes a source of inspiration for those engaged in similar struggles in different states. These victories carry considerable significance, establishing precedents and providing a roadmap for others in the expansive fight for constitutional rights. Consider a scenario where a jurisdiction in California prevails in a case challenging firearms restriction. The impact isn't confined to the state's borders. It's akin to a catalyst that sparks initiatives in other regions, offering a foundation for arguments and strategies in cases situated miles away. These victories become points of reference, guiding lights that suggest, if it worked here, it might work there too. Take for instance the recent successes in California's Miller v. Bonta and Duncan v. Bonta. These triumphs transcend the boundaries of the Golden State. They've woven themselves into a larger narrative in the ongoing battle for firearm rights. The arguments and rulings from these cases are being employed as supportive precedents in the fight against suppressor bans in Illinois and potentially influencing similar cases in various states. Triumphs across different jurisdictions aren't merely about reveling in individual successes. They're about cultivating momentum. They foster a network of legal support, where successful arguments and rulings in one locale became ammunition for battles elsewhere. This ripple effect mirrors a domino effect, each triumph nudging the next and influencing legal landscape to fortify the broader fight for constitutional rights. These victories serve as integral components in the overarching mosaic of firearm-related rights nationwide. They're not standalone achievements, but interconnected elements that contribute to a tapestry of legal precedents, shaping the understanding and interpretation of constitutional rights in diverse jurisdictions. So, when news breaks out about triumphs in two-way cases across different states, recognize that these victories extend beyond individual circumstances. They are pivotal elements in a larger movement, paving the way for challenges against restrictive laws in various areas and offering hope and support to those actively fighting for their rights. This dynamic creates a legal landscape where each success holds the potential for broader and transformative change. In a legal showdown, in the intense legal dance of the Illinois suppressor case, the judge executed a move that set legal circles abuzz and hearts pounding. Picture the courtroom charged with anticipation, and then, in a crucial moment, the judge subtle nods, allowing two heavyweights, Miller v. Bonta and Duncan v. Bonta, the supplemental authorities, to step into the legal arena. Now, why is this causing such a commotion? These aren't your average court decisions. They come from California, where they made waves by deeming certain firearm restrictions unconstitutional. And now, they're making an unexpected appearance in the Illinois Suppressor lawsuit, like surprise guests at a party who might steal the show. The judge's decision to admit these supplemental authorities isn't mere protocol. It's a game changer. It's as if he's saying, let's bring in these California decisions and see how they align with our Illinois case. This move has everyone on edge, contemplating the potential impact of these heavyweight rulings on the unfolding drama in Illinois. These decisions aren't just legal documents, they're power players. Their inclusion signals their significance and potential to sway the outcome of the Illinois Suppressor lawsuit. It's like casting a spotlight on recent victories against certain restrictions, suggesting that they could serve as a precedent for similar cases elsewhere. Their admission into the Illinois case goes beyond a perfunctory acknowledgement. It recognizes their potential impact. These rulings are being presented as compelling evidence, conveying, "Judge, look at what happened in California. Those decisions against certain restrictions, they could chart our course here in Illinois too." Their presence in the courtroom isn't a mere spectacle. It's a source of hope for those opposing suppressor bans in Illinois. The judge's acceptance of these supplemental authorities isn't just a routine legal step. It's a significant development underscoring their potential impact. It's like laying down a trail of legal breadcrumbs, suggesting that recent triumphs against firearm restrictions elsewhere could potentially pave the way for a similar outcome in the Illinois fight against suppressor bans. As the Illinois case unfolds, the inclusion of these California decisions isn't a mere footnote. It's a narrative element that could weave into the final judgment. Their acceptance indicates a willingness to explore how recent victories against firearm restrictions might hold relevance and influence the course of the Illinois Suppressor lawsuit, offering a glimmer of hope to those advocating for broader firearm rights. Legal tremors. Envision this scenario. The Illinois Suppressor case reaches its climax, and the judge's gavel falls, overturning suppressor bans. What unfolds next is akin to a legal earthquake, sending seismic waves across the nation, poised to reshape the landscape of firearm rights. Should the Illinois case against suppressor bans yield a favorable outcome, it could set off a chain reaction with sweeping consequences.
Well, the Arizona Senate has passed a bill to make it easier to own a gun silencer, more accurately called a suppressor.
Gun enthusiasts hope lawmakers will pull the trigger and lift the ban on silencers.
To buy a $900 silencer like this one, you'll need an FBI background check, $200 in fees.
Asserting, this ruling establishes a precedent. It challenges the notion that suppressors aren't protected under the Second Amendment. It's akin to illuminating a path, demonstrating that bans on suppressors may not withstand constitutional scrutiny. Yet, it goes beyond legal arguments. It's about generating momentum. A favorable decision in Illinois could invigorate similar battles across the nation. It could empower those championing suppressor rights in other states, providing a source of hope and a compelling argument to contest existing bans. This potential impact isn't confined to suppressors alone. The ripple effects of this decision might extend to challenges against other restrictive firearm laws. It has the potential to bolster the broader fight for Second Amendment rights, shaping a legal landscape where victories in one jurisdiction become ammunition for battles in others. The Illinois decision could evolve into a tool in the arsenal of those fighting against unwarranted restriction on firearm accessories. It opens up a new legal avenue, suggesting that the right to own and use suppressors might be more robustly protected than previously acknowledged. However, it's crucial to emphasize that this remains speculative until the judge renders the final decision. A favorable outcome in the Illinois suppressor case doesn't guarantee that bans in the other states will crumble like dominoes. Nevertheless, it acts as a catalyst. a potential game changer that could initiate a series of legal challenges and pave the way for a broader recognition of suppressor rights across the country. That's all for this video, folks. See you next time.